Clearing number. As directed by the Honorable Court, Milord, I have prepared one synopsis.
All the parties are, but we have a batch of petitions. Everybody is ready.
I am reading Milord, but rest
we appreciate that, but otherwise हमको नहीं सुना. The other day consent of parties से आज रखा था top of the list इसलिए.
Milord, the state is here.
All the matters are similar.
Yes, Milord, absolutely, sir.
And you are representing in how many cases?
32 matters. 32 matters.
Only one case.
32 matters, Milord. Total 32.
You are representing majority of the matters.
Yes, Milord. And my learned friend is also 3 cases, Milord. 3 matters. So it's 35.
And how many cases are total? 47. 48. Okay, we'll start.
Lead actually it's item 112.2. Madhya Pradesh Anusuchit Jati 807.
The lead case is Ashwat Chaudhary.
I'm saying that our exhaustive return is in that matter, and I would be referring to that also.
So we'll see that return also. We can commence hearing?
Yes.
Everybody ready? Yes. Approximately how much time it will take?
15 minutes. Hardly 15 minutes. 15, 1-5.
1-5.
These are the synopsis. I say we are on the same footing. All the petitioners are on the same footing.
Which is your lead case?
Kishore Chaudhary. 5/4/2021.
And return, Mr. Bernard, return is? I'm sorry, return is, you are referring to return in which case? Please tell us WP
7. But since my marking and all is exhaustive petition, and that petition will challenge the act and the rules and everything. Some petitions will challenge.
Right. Yes.
Milord. Initially on 14/11/2019, Milord, the MPPSC has published an advertisement for Madhya Pradesh State Services Examination of 2019. And the advertisement for the next day's election has P1, Milord, at page number 24 of my compilation.
Mentioned annexure number also here. In your events.
So, I'm so sorry, Milord. So it's even, Milord. Thereafter, Milord, the petitioner has submitted his application form on 2/12/2019. And the exam of preliminary exams, Milord, were conducted on 12/1/2020.
Yes.
But so far as here, this up to 12/1/2020 is concerned, Milord, the Madhya Pradesh State Services Examination Rules 2015 were in force. 2015, my lord. I filed that page number 68, annexure P4.
Page
68, annexure P4.
68.
Yes, my lord. Thereafter, my lord, during the this ongoing examination, conduction of the preliminary exam, the state came up with an amendment, my lord, and it was ratified on 17/2/2020. That is after the examination was started. That amendment, along with my compilation, as annexure P6, my lord, at page number 166.
With the petition itself. Petition itself.
Petition.
Page 66.
My lord, it's page 6, my lord, page 166.
166.
Yes, ma'am. Now, in this amendment, my lord, the impugned part is, my lord, his English version is at page 174. This is how they say the mode of preparation of the select list, I mean, of the qualifying list changed during the ongoing examination. My lord, I'm reading part. This is rule 4. When rules shall be substituted, namely, mode of the preparation of select list. is on the basis of marks obtained in preliminary exam, category-wise candidate numbering 15 times of the vacancy as advertised will be declared successful for main examination, subject to the condition that candidates have scored minimum passing marks, as may be specified in the commission. In addition to this, all other candidates who get the marks equal to the cutoff marks will also be declared successful for the main examination.
Mr.
Next, number 2 is
Please, then we'll request you to read it again. We'll request you to read it again for some reason.
my lord.
Yes.
On the basis of marks obtained in preliminary examination, category-wise candidates numbering 15 times of the vacancies advertised will be declared successful for main examination, subject to the condition that candidates have scored minimum passing marks as may be specified by the commission. In addition to this, all the other candidates who get marks equal to cutoff marks will also be declared successful for main examination. B is what? Separate list of candidates applied in unreserved, scheduled caste, scheduled tribes, and other backward class and economically weaker section shall be prepared. Reservation shall be given to women and ex-servicemen in all categories as per the rules and instruction issued in this regard from time to time. The part which is affecting us most, my lord, is page number 178. Now, when we prepare separate list, my lord, the unreserved category, scheduled caste, scheduled tribes, OBC, and economically weaker section, my lord, all these are vertical reservations. And the relevant MPU, my lord, is at page number 178 of my compilation. And then 180, my lord. I'm referring to first 178, class 2, my lord. Firstly, list of unreserved candidates will be prepared. So it is in the rules, my lord, that they have to first prepare an unreserved category list. My lord, the relevant part which is affecting us is at page number 180, my lord. This is D. The whole rule D, my lord. Result of preliminary oblique main examination, the candidate shall be declared in the category mentioned as their category, their online application form. My lord?
D1.
D1, my lord. Again reading it. Results of preliminary oblique main examination, the candidate shall be declared in category mentioned as their category in their online application form. Second, candidates of reserve category, scheduled caste, scheduled tribe, other backward classes, economically weaker section, get selected. The general category candidates without any relaxation should not be adjusted against the post reserved for those reserve categories. They shall be adjusted against the vacancy of unreserved category. The third, my lord, that above adjustment will only be at the time of final selection, not at the time of preliminary and mains examination. So, my lord, a student belonging to SC, ST, OBC, or economically weaker section, my lord, was not permitted to go in unreserved category list, even if he gets the higher marks. So, actually,
Is it like that, or is it, if we read subject to what you suggest,
my lord,
says that if reserve category candidate occupies position in general category on his own merits, he will not eat up the vacancy of reserve category.
Correct.
It will be treated to be a general category.
yes, my lord.
Right, but 3 says, but above adjustment will only be at the time of final selection.
Yes, my lord.
It's in the final selection, they will treat those candidates as reserve category candidates.
Yes, my lord. So my difficulty is, my lord, if I obtain higher marks than a candidate who belongs to general category, I will not be permitted to go into the unreserved category. If I belongs to SC, ST, or OBC, despite having merit, I will not be permitted to go in the UR list. Actually, they have made a list of general category students in place of UR categories students. UR category, my lord, is an open category. All the backward class students can go into that category based on their merits. If actually a bar has been created, so being a SC, ST, OBC candidate, you cannot go in the UR category. Even if you
Yes, your reading is correct.
this honorable court will not specifically ask this question whether the list prepared by the state, the MPPSC, in the UR category list, whether all the candidates are general category and they have admitted it. So thereafter they realize their mistake, my lord, and therefore they have substituted this rule, my lord.
List they have prepared is after the preliminary examination.
Yes, my lord.
As pursuant
By declaring the result of preliminary examination, my lord, they have applied this rule with retrospective effect.
as per B2, as per D2, they were required to apply.
Yes.
And but this was confined to preliminary examination only.
No, my real man. To apply every type of final selection. Final selection only. After the
Not in preliminary.
not in preliminary, not in mains. So they'll restrict me.
D3 says audition will only final section.
That's right.
It means it is applicable for final but not preliminary.
Not preliminary, not mains. Both.
Why not means final selection kya hai na?
It is there in the law. It's not every time.
Public main exam.
Public main exam. So even if I get marks on that, I will not be permitted to go on the UR list. And they realize their mistake. The state has realized their
What is
mistake.
the meaning of is if it is not applicable in preliminary and main both,
Yes, ma'am.
it means it is not applicable at all.
Yes, my lord.
There are two exams only, preliminary and main.
And interview, my lord. The preliminary exam is qualifying examination. The marks obtained in the preliminary examination will not be added to the final marks, my lord. And so far as marks of mains examination is concerned,
It is aggregate of main and interview.
That's right. So here, after this, my lord, when we raised this objection and the question came, the state came up with a resolution plan and they said that we are.
So it means as if we read it as such, it will be applicable after the interview.
Yes, ma'am. Exactly.
It is for main examination and interview put together, and in that only it is applicable.
That's right. G.
That is their stand.
Yes, my lord. That is their stand. Since it was unconstitutional, my lord, they themselves have gotten new rules, my lord. And thereafter, my lord, new rules of 2021 came into. Because they declared the exam, the preliminary exam result. In these rules, the amendment of 2020, which just my lord have read, and thereafter, my lord, the results were declared on 2/1/2021. 12/21/12/2020.
When preliminary is result declared, preliminary examinations
21/12/2020.
and main.
Means, my lord, later on, mains were conducted. The results of mains examination, my lord, were declared on 31/12/2021. Before this, my lord, they brought further an amendment by way of amendment 2021. This was notified on 20th of 12/2021. And they rectified their mistake. So like now the question is the effect and operation of these amendments, the amendment of 2020, the amendment of 2021, and since they have brought these amendments by way of substitution, this will have retrospective effect and factually will have a retroactive effect. So they have to reevaluate, they cancel the mains examination and results, reevaluate the results of preliminary examination without conducting the preliminary exams afresh. Relying on certain judgments.
No, but if we agree with substitution part,
Yes, ma'am.
that substitution relates back to the date of original enactment.
Yes, ma'am.
In a nutshell, your argument.
Yes, ma'am.
Then we need not to declare it as ultra virus.
Yes.
And if we decide it otherwise, it's a loud thinking subject to hearing. If we decide otherwise, then you will have to press on
Correct.
virus also.
Yes, ma'am.
That for this period up to 2012-21,
Yes.
the unamended provision was in vogue.
There are multiple judgments, even
Proceed in the
judgment, Miller, I'm starting with this only. The judgment, but I'm relying on para 63, 67, and 82. Wherein this Honorable Court precisely stated,
that's Viva Highways.
my lord.
Etc.
My, 63, my lord.
My learned friend can give us a citation also.
Give me a copy.
Copy.
Just give me, just read it and hand it out. Sure. 2017. 2017, volume 2, MPLJ. Paragraph 63, I'm relying.
Fifty-three.
63. In our view, since intention behind the amendment is to clarify.
Really?
I'm sorry, but since photocopy shops are,
Just proceed.
my lord. In our view, since intention behind the amendment is to clarify that concession agreement will also fall within the definition of work contract, it will be an amendment by way of earlier definition is substituted and not superseded. In other words, there is difference between supersession and substitution of a provision. See so and so, my lord, thereafter. State opined that when amendment is made by substitution of a provision, it has the effect of replacing the old provision by the substituted provision. In absence of repugnancy, inconsistency, absurdity, it must be construed as if it is incorporated in the act right from ab initio. Hence, in the present case of substitution of definition, it will be presumed that the amended definition is in force from the date amended definition came into force. Apart from this, para 67, my lord, we are not obvious of the fact that this order may create inconvenience in certain cases where parties may be required to resolve their dispute before a forum constituted under 1983 Amendment. However, inconvenience, etc., cannot be ground to interpret a definition or to provide a redressal forum, which is otherwise not available as per law. So, that even what would be the effect is not to be seen when the amendment is brought by way of substitution. So, since the Amendment Act of 2020 and the Amendment Act of 2021 brought into force by way of substitution, it will come in effect from year 2015. Then I'm relying on Rajasthan's judgment and Zile Singh's judgment, which is the factual basic judgment. Citation. Relying on para 14, 15, and 22.
Para 14,
14, my lord, 15, and 22.
25.
22, my lord. 14 says the presumption against retrospective operation is not applicable to declaratory statute. In determining, therefore, the nature of the act, it must be held to the substance rather than to the form. If a new act to explain, an earlier act would be without object unless construed retrospectively. An explanatory act is generally passed to supply an obvious omission or to clear up the doubts. To the meaning of the previous act, it is very simple that if a statute is curative or merely declarative, the previous law retrospective operation is generally intended. An amending act may be purely declaratory to clear a meaning of a provision. The principal act, which was already implicit, clarificatory amendments of this nature will have a retrospective effect. 15, though retrospectively it is not presumed, rather there is presumption against retrospectivity. According to Sancho, it is open for the legislature to enact laws having retrospective operation. This can be achieved by express enactment or by necessary implication from the language employed. It is a necessary implication from the language employed that the legislature intended a particular section to have retrospective operation. The court will give it such an operation. In absence of a retrospective operation having been expressly given, the courts may call upon to construe the provisions and the answers the question whether the legislature had sufficiently expressed that intention, giving the statute retrospectivity. 4 factors are suggested as relevant: general scope of preview, the statute, the remedy sought to be applied, the form state of law, and what it was the legislature contemplated. The rule against retrospectivity does not extend to protect from the effect of repeal a privilege which did not amount to accrue the right. Para 22 also. The state legislature of Haryana intended to impose the disqualification with effect from 5/4/1995, and that was done. Any person having more than 2 living children was disqualified from the day for being a member of the municipality. However, while electing a provision by way of an exception, carving out the fact situation from operation of newly introduced disqualification, the enforcement's folly caused a creation trouble. A simplistic reading of the text proviso spelled out a consequences which the legislature had never intended. could not have intended. It's true that the second amendment does not expressly give an amendment a retrospective operation. The absence of a provision expressly giving a retrospective operation to the legislation is not determinative or its prospectivity or retrospectivity. Intrinsic evidence may be available to show that amendment was necessary intended to have retrospective effect. The court can unhesitatingly conclude in favor of retrospectivity. The court would not hesitate in giving the act that operation unless prevented from doing so by any mandate contained in law or an established principle of interpretation of statute. So, my lord, so far as the amendment 2021 brought into force.
Before that, why don't you show us the amendment?
Yes,
Language used.
they just came back to 2015 with very.
What is the language used?
I'll just-
Substitution, deletion, what they have said.
Let me remove amendment of 2021.
That is at page
I'll just pass it on the list.
We find it on record in WP 807.
7 में निकाली थी.
For the convenience of this,
I have read copies of the entire 2015, 20 and 21. I'll hand that over. But that amendment is on.
First is that it is substitution
yes, Mr.
and therefore it should relate back. Let's see what is the language of that.
I filed it as a document, taking a document on record in WP 807.
उसको भी flag करना.
Amendment is there.
The English version is at page number 60, which I have marked, my lord.
16.
60.
807.
My lord could get it. 60, my lord, in rule 4, sub-rule 3, clause A, following clauses shall be substituted. 3A1, after the interview, the merit list of candidates shall be prepared by commission on the basis of total marks obtained by them in the main examination and interview. The order of merit of the candidate securing equal marks shall be determined as per criteria prescribed by the order of the commission. First of all, list of unreserved category, which includes SC, ST, and other backward class economically weaker section shall be prepared. Now they have clarified this method that while preparing the list for unreserved category, SC, ST, and OPC and economically weaker section shall be prepared. After this, those candidates belonging to reserved category, scheduled caste, scheduled tribes, and other backward classes, and economically weaker section included in the unreserved category, which also includes scheduled caste, scheduled tribes, and other backward classes, and economically weaker section, taken the benefit of relaxation from time to time, shall be included in respective category by separating them from the list of unreserved category. Secondly, separate list of candidates belonging to scheduled caste, scheduled tribes, and other backward classes, and economically weaker section shall be prepared. Women and ex-servicemen candidates in all categories shall be given the benefit of horizontal reservation as per rules and instructions issued by the state government in this regard from time to time. Posts advertised for various category persons with disability. Only the person of that disability category shall be selected. Such female ex-servicemen and differently able candidates who have already been selected on the basis of their different categories, that is, unreserved, scheduled caste, scheduled tribes, and OBC economically weaker section, shall be counted as per reserve for the same category against the said post. 7, such female ex-servicemen and differently.
This is important, no? 6.
6, yes. Such female ex-servicemen differently
For the same category mean the category on which they are selected on merits.
the same category. This is horizontal. If a candidate has filled this from SC category and is disabled, he or she shall be interested in the same category.
It's a horizontal. Vertical.
This is horizontal.
Servicemen and differently able.
This is horizontal.
This is horizontal.
Yes, ma'am.
Who have been selected on the basis of their merit in different categories.
Yes, ma'am.
If somebody is female as well as reserve category,
Then the vertical one. She'll get
one category.
Yes, ma'am. So far as this rule is concerned, there is no difficulty. But so far as the amendment of 2020 is concerned, which is in question before this honorable court, that would be applied. Even that period duration was applicable. So far as my interpretation is concerned, the amendment brought in by way of substitution, it will have the effect from 2015. So if 2021 brought into force, the amendment of 2020 has lost its significance. So it is not even required to be declared as ultra virus because it is no more in existence. And the effect of 2021 will come into force the moment they have brought into, they have notified it. So the effect of bringing this amendment would be changing the, cancelling the result of.
Khandelwal, will again bother you to come to the main provision at 180.
Main provision will add it?
180, page 180.
Yes, my lord. D3, my lord. It is in dispute.
The effect of D2 is that they will, that even if somebody has secured position on merits,
yes, ma'am,
as a general category, his position, he will not occupy a position in general category.
He will occupy in general category, but the SC, ST, OBC members will not go in your category.
See, that is what we are asking, that this vertical reservation beneficiary, if they secure more marks than a general candidate,
yes,
even then they will remain in their own compartment.
This is the difficult.
This was the previous position.
Yes, ma'am.
They say that it will not be applicable at the time of preliminary and main.
Yes, ma'am.
It will be applicable in the time of main exam.
Yes,
in the final list.
Final selection list.
Final selection. So this will deprive you to succeed in fact, it will reduce the numbers in preliminary examination and in main examination.
This will do a lot, and apart from this, it's a.
जो candidates आपके general में आते हैं वो general का occupy करते हैं.
Yes.
तो आपके reserve में ज़्यादा number candidates benefit मिलता.
Not general, but UR category is open for all. My question is, UR if is open for all, the citizen of this country, in fact, the candidates. UR category.
It's a different question.
Hello?
If you are selected in UR,
yes,
they are not denying selection.
Yes,
they are cutting the percentage from horizontal reservation.
Correct.
Right.
Yes,
so this results into you would have been given the birth in the merit in UR, then more number of OBC, SC, and ST candidates would have occupied seats.
That's right.
This is in nutshell.
That's right.
Yes.
And while preparing the rule of 2020
is taken care of in the new rules. How it is taken care of in the new rules.
Just clarify that the UR list would be inclusive of SC, ST, OBC. That clears everything.
Which is that one?
But this is at 60.
It takes care of this so-called unconfirmed.
432, my lord.
432.
First of all, a list of unreserved category. Then within bracket, which includes SC, ST, OBC, other backward classes, economically weaker section shall be prepared. After this, those candidates belonging to reserved category, scheduled caste, scheduled tribes, OBC, so and so, are included in the unreserved category, which also includes SC, ST, OBC, and economically weaker section, who have taken benefit of relaxation from time to time, shall be included in respective category in separating them from list unreserved category.
From the list of.
So first they'll prepare your category, then thereafter they'll bifurcate.
Yes. बाकी लोग बताइए एक-एक करके बहस करिएगा. You take seat, let him finish. If you want to add, we will let you. Yes.
So in my respectful submission, my lord, the effect of bringing this amendment by way of substitution will result in cancellation of the mains exam completely, declaring the re-evaluating and then declaring the exam results of preliminary exam, so that the qualifying examination will I'll be out of the qualifying examination. I will not be able to appear in mains examination or interview. So at very initial stage, because of this impugn provision, they may be out. So this is my respectful submission. Preliminary exams ke jo results hai, that would be re-evaluated based on the examination already given by the candidates.
That's all.
That's it.
But while bringing this amendment, is there any aim and object of the amending provision is force?
But they say that it was
In the enactment itself, with aim and object is not mentioned.
it's not mentioned. Absolutely nothing. Nothing is mentioned. But as I
A simple argument that is substitute for. Aim and object. Examination would be put back, and from there it should be restarted. so that this formula can be applied. If you wants to add anything in petition for petitioner,
But one more thing that I just want to add. They also have to apply the provisions of Act of 1994, my lord, which provides for the percentage of reservation which is to be given to the candidates. Now, the percentage fixed in the Act of 1994, volume 22.
this is very
I have some limitation. I participate in examination. I can not question it. Just whatever have been further committed. This example, purpose of reservation. I might take up on number 32, 1.2.32 item. The chart has been taken. This this section for that is chapter 1995. Fixation of percentage of reservation of post and standard of evaluation. This is provided by and the staff. The post reserved for members of scheduled or OBC shall not be filled by members who do not belong to such caste or category. Access as may be. Subject to the provisions of this Act, they shall be reserved for persons belonging to SC, ST, BC, stage of different recruitment in public services and posts. The state level, the percentage of vacancies arising in a recruitment year in class 1, 2, 3, and 4. Class 1 and 2 scheduled caste 16%, scheduled caste 20%, class 3, 4, scheduled caste 16%, 20%, respectively. Judgment alternated 22 number. This question
yes.
Second of the item, when it comes for professional data submitted that PSC may be directed to put on record the data of previous two selections which were conducted under the unamended rules of 2015. The amendment introduced in 2015 against the data of selection in question. Amendment has also been raised that out of 571 total advertised seats, 16% seats reserved for SC candidates should be 91 posts. Only 79 posts have been notified. Similarly, on the basis of 20% quota of SC candidates, there have been 144 posts, whereas only 102 posts have been reserved for SC candidates. Stated is that against 154 total posts, which constitutes 27%, total advertised posts, 192 posts have been created. There was a dispute with 14 and 27%. They exceeded to 33%. Reservation which is given in the examination without is also not, they have not followed the Act of 1994. They have not followed the rules of 2015. They have not followed the amendment of 2020. They have not followed the amendment of 2021. Resulting to a lot of petitioners and other eligible candidates who are similarly situated, lost their chance to qualify for this examination. The examinations,
What happened to your petitioner in this case? He did not qualify.
One question. The OBC category are saying it's almost impossible. The entire OBC should go to the UN category. It's only one question. But it's technically appropriate in the position method. But we need to see how it has been prepared. This is a category
This chart is prepared on the strength of.
on the strength of result declared, impugned result were not declared by the respondent number.
There is no quarrel about
Not at all. Not at all.
So you are 146.
Yes, ma'am.
Your is 146.
Well, I got 144 marks. One question is of 2 marks. But
You got 144 and Your section is 146
Yes, my lord.
and OBC
146. If the candidates belonging to OBC would be permitted to enter into your category based on their merits and marks obtained, then I'll be the first person to enter into the OBC category.
you have you required 144. The
I
cutoff is
have
144.
144.
But the cutoff is 146.
Which is wrong. Which is wrong. If the cutoffs, all the candidates belonging to OBC category who have obtained secured more marks than 146 have been included in this list. Same is the fixation of your category. And this entire list has not been adjusted in the your category based on their merits. The OBC candidates and other backward classes candidates cannot be restricted to the your category based on the marks obtained.
All such persons, those who have reserve category person, those who have more marks should
Your category.
in your category.
Yes, ma'am.
So that will result into more space in your category.
Yes, ma'am.
In nutshell.
Yes. This is in sum and substance.